In this second session, we will explore the critical legal frameworks and the privacy implication on government requests around this topic. I'm really pleased to introduce you also to the moderator of this session, which is Maria Julia Baumert. I hope I've been pronouncing the name correctly. Maria is correspondent at MLEX, which is a leading service for market insights and regulatory intelligence. So I'm really pleased to have her with us. And together with me and Maria, we will have three other speakers, which are respectively Mariano Peruzzotti, partner from the Argentinian law firm Allende Brea, which is, of course, our local member for the PrivacyRules Alliance, together with Mason Clutter from Frost Brown Todd in the US, and Alexis Cervantes, partner at Davar Abogados in Mexico. So 3 partners from 3 different jurisdictions with a journalist, a correspondent working on the topic for another great panel. Maria, I will leave the floor to you. I'd like to thank you all for this session, for being here, and looking forward to listening to you all.
Hello everyone, it's great to be here and to moderate such an incredible panel. I'm not going to steal time from any of you guys. So in a brief summary, I think Alessandro already explained it, but the plan is in this panel to explore how governments are dealing with the challenge of processing, dealing in analyzing biometric privacy. I would like to start with Mason and with the US. In the US so far, there's no comprehensive federal law governing biometric data, but it's still heavily used on airport control, immigration, and security related. Can you share a bit about the intersection of biometrics and government access? And are there any laws or rules that govern how law enforcement collects and uses this data, including through private companies?
Yes, of course. Thank you so much, Maria, and great to see you, Mariana and Alexis. I hope you can hear me. I'm having some tech issues today, so if I cut in and out, please excuse me. Yeah, I like this question. So I'll set the framework here if we have a framework. As you said, we do not have a comprehensive framework in the... So starting at the US state level and then working up to the federal level. From the state perspective, we obviously have 19 different state consumer privacy laws. These consider biometric data to be sensitive information. And so for most states, effectively means that they must obtain the consent of the individual to collect and use the biometric identifiers. We also have a framework of state-specific biometric laws that are directed at the private sector. Texas and Washington state. Many of these laws provide for a private right of action. So as you can imagine, they can be very costly for businesses if they do not comply appropriately. But the good thing about these laws is that they really do establish an easy to follow framework for the collection, use, retention, and destruction of biometric information. So the challenge of knowing about them and then complying with them is called. And for both of these, whether state consumer privacy laws or the biometric specific laws, we're always allowing law enforcement access to this information pursuant to legal process in the United States. So that brings us to the quote federal framework, obviously with our US Constitution. And in our US Constitution, it's from the 1700s, but we do rely on the 4th Amendment, which provides for a right against unreasonable searches. So the use of the biometric information and seizures, which would be the collection of the information, and requires a probable cause standard, which is reasonable suspicion, to obtain what we call a warrant. So this would be a document that a judge signs off on that says you meet the constitutional standard to conduct a search or a seizure, and then that paper is delivered to the holder of the information, whether it's private sector business or the individual themselves, to then collect and search and use that information. Our law enforcement in the United States also, upon arrest, so again, meeting that constitutional standard, or arguably a general standard under the Fourth Amendment, collects biometrics upon arrest in this country. And we know that most familiarly with fingerprinting, right? And so that's been a part of our long history. And then finally, post 9/11 in the United States, there was a congressional commission that assessed the attacks and to verify identity, given entered and stayed in the United States. And so one of the ways, again, remember, this was in the early 2000s, so long before biometrics were really common. Congress suggested that the federal government consider the use of biometrics for identity verification or entry and exit under short-term stays or even immigration stays. And of course, in the United States, then the federal government and the national security ran with this. And so, as you mentioned, our most known and commonly public use of biometrics is for international travel to enter or exit the United States by non-US citizens. So if we use facial recognition as an example of the intersection of AI and biometrics, we know that this technology can be imperfect, and oftentimes it's inherently biased in a way that is not helpful to the particular use case. So without particular or appropriate safeguards in place to mitigate these potential, if somebody is solely relying on biometric matching in a law enforcement context, it has led to innocent individuals being targeted for investigation or even arrested in this country. And this obviously raises unique privacy, what we call civil rights and civil liberties, and even reputational issues for these individuals, which can be hard to recover from. So these are some of the issues that we are still dealing with as biometrics become more prominent in the United States. And I'll stop there because I think we're going to do a little bit of a deeper dive into the particular one department and how they may use biometrics later in the conversation.
Yeah, we'll definitely have a second question. So now let's turn to Alexis and to Mexico, where big changes are underway with the new national identity system. So the system combines fingerprints, iris scans, and photos to one identity platform. At the same time, we see Europe moving in the opposite direction, calling for strict necessity tests and even bans on certain biometric uses. Alexis, from your perspective, what would a minimum acceptable legal framework would look like to reconcile these big infrastructures with fundamental rights?
Hi, first, Maria, and yeah, you're right on, and I think that it's relevant to give this context that what's happening right now in Mexico in terms of the use of biometrics and how they're, especially the government, how they're expanding its biometric and intelligence capabilities and at an unprecedented pace, I would say. And why is that? Because of the examples you provided. We are the Mexican government this last year has radically changed to curb on key, what we call the Biometrics and digital identity. And one of the most serious topics that's been happening in Mexico is the design of a central intelligence platform, which is designated to enable greater interoperability across public services. And at the same time, this new legislations in terms of security, that of course it's understandable, but what we have to understand is that they're expanding all these analytic tools that are going to require, of course, the massive processing of Mexican citizens, and are going to require the processing of biometric data. And how the law is designed is to be these communications between government officials and government authorities with private sector companies. So this central intelligence platform, of course, we understand the purpose for which is created, but of course it raises a lot of concerns in terms of safeguards and data privacy. And on the other side is that our data protection landscape has changed radically. No, as all of you or most of you know, or if you don't know, Mexico. Previously, in Mexico, we had an autonomous independent authority that it's INAI, which safeguarded the data protection right, both for the processing of public entities and private entities. And because of the constitutional reforms that occurred in Mexico, that INAI disappeared, and the new authority of data protection is under the executive branch and under the Secretariat of Anti-Corruption and Good Governance. So, as I mentioned, is from in one side we have these new laws that are going to require the massive processing of Mexican data, citizens' data, specifically biometrics, and the other side we have a new data protection authority that is just a couple months into action, and that is going to have, of course, the main responsibility to safeguard the data protection right and to prevent any unauthorized uses of that data from Mexican authorities, especially, again, facial recognition technologies and the new identity technologies that are going to be used in a short period of time. So that's where we are right now. That's going to be the challenge, and we're going to have to see how this new authority reacts to this huge challenge that we're facing right now in terms of data protection.
Nice, perfect. And shifting to Mariano and Argentina, I believe we are in a close situation, Brazil and Argentina, where the biometric use of data is currently governed by the privacy data protection law. Luisa explained that earlier. So, Mariano, can you explain a bit how the current legal framework regulates the collection and use of biometric data by public authorities? And looking ahead, I see there is some major news coming also. What are the main legislative and regulatory reforms expected in the next 2 years regarding the biometrics?
Sure. Thank you very much. Thank you for having me here. It's a pleasure to join this panel with Mason, Alexis, and Maria. And thank you to all of you for joining this session. Well, yeah, as you point out, the collection and the use of biometric data by public authorities is mainly governed by the general data protection principles and rules, as well as the relevant regulation issued by the local authorities. In Argentina, we have the Argentine Personal Data Protection Law, which does not include any specific reference to biometric data. And the reason behind this is very simple. The law was enacted in the year 2000, and it was not subject to important adjustment or reforms. So that's the main reason or the main ground why you will not see any reference in the Argentine data protection law concerning biometric data. Even considering that the Argentine law was inspired on the European data protection regulations. Besides this, Argentina joined Convention 108 and Convention 108 Plus of the Council of Europe. And as you probably may know, this convention specifically addressed the processing of biometric data. Having in mind this, the Argentine Data Protection Authority issued Regulation 4 of 2019, which approved a set of guidelines on the application of the Argentine Data Protection Law. These guidelines include a specific section on biometric. And this section states that biometric data will be deemed sensitive data only when it may reveal additional information whose use could potentially result in discriminatory treatment of the data subject. For instance, data revealing ethnic background or health-related information. As you probably may know, sensitive data, according to the Argentine Data Protection Law, and it's similar to different regulations around the world, is subject to a more stringent regime. For instance, in Argentina, if the authorities, the public authorities, will collect and process sensitive data, they have to obtain the consent of each data subject or has a legal authorization for this processing. This is the current situation nowadays. As some years ago, in year 2022, a bill aimed at amending the data protection law was introduced in Congress. This bill considered the biometric data as sensitive data, but unfortunately, this bill had never been discussed in Congress and finally lapsed in year 2024. But the DPA has recently voiced that they will resume negotiations and discussions to reintroduce an amended version of the data protection bill next year. In fact, last week we have participated in the first round of discussions with the Argentine Data Protection Authority in the sense of resuming this kind of discussions.
That's very, very interesting. Going back to the US and to Mason, Mason was Chief Privacy Officer at the Department of Homeland Security. Homeland Security is a key agent in the United States framework. So, can you speak to the ways in which the department and its many law enforcement agencies use biometric information and using facial recognition as an example? Where do you think are the safeguards that we need at play at the moment? And are there any challenges in your experience there at the Homeland Department? How did you address them?
Thanks, Maria. So I'm really glad we're having this conversation today, because I think as privacy experts, we certainly appreciate that biometrics are incredibly sensitive information, right? These are immutable traits that somebody cannot change. So not only can they be incredibly helpful and beneficial for, private sector businesses. I know we heard Lindsay speak in the previous panel about the ways in which companies are using biometrics to facilitate security and time card keeping, et cetera. We also have to balance that with the potential risks to the individual, because you can't change your face, you can't change your fingerprint, you can't change your DNA, right? And so when you think about private sector use is very risky, especially from a security perspective, but all of that biometric data that is being collected in the private sector, as I mentioned earlier, is subject to potentially law enforcement access, which is where the intersection of rights and freedom and even life in this country can come into play. So I want to be clear that when I was at the Department of Homeland Security, I left in August of 2024, so I can speak to my experience then. But as I mentioned previously, and as you said, Maria, most visibly, use by the Transportation Security Agency for our domestic security at the airports, and use by Customs and Border Protection to facilitate international entry and exit, also to verify identity. Again, these are considerations from the 9/11 Commission, are what people see most visibly in the United States. So I'll say one of my claim to fame, if you come to the United States, you will see at the TSA checkpoints a big stop sign that says, stop, you don't have to go through this process and you won't lose your place in line. From a domestic perspective, there's an opt-out right for everyone. When we're talking about CBP and international travel, unfortunately, there is not an opt-out right for non-US citizens, but there is in this country for US citizens. The department also used biometrics for voluntary programs. So in the United States, we have international travel programs domestically called Global Entry. This helps individuals go through customs and their return from international travel seamlessly and more easily without having to wait in lines. It uses your biometrics to, again, verify your identity. Same thing for what we call the pre-check process through our domestic security apparatus. But I will highlight that these biometrics that are collected for these voluntary programs go into the same database, but they are supposed to have different guardrails around their use. Now, guardrails, again, as we established, are policy-based. In the United States, we do not have a comprehensive law with respect to law enforcement and the use of biometrics, notwithstanding the Constitution. And so your guardrails really are only as foolproof as the individuals who are implementing them. The department also used biometrics to facilitate provision of immigration benefits. So again, in this context, to verify identification and ensure that benefits were being assigned to the correct individual. Now, recently, I saw a notice of proposed rulemaking from the Department of Homeland Security, specifically the USCIS, Customs and Immigration Services, to begin collecting from everyone biometrics, including potentially DNA for familial verification. And so again, when we're talking about potential risk, we can certainly see the benefit in the context of immigration to verify that an individual is a member of a particular family. But there are risks there with respect to, of course, secondary uses. And again, DNA reveals a lot more than just familial verification or familial ties. So how is that going to be regulated? What are the safeguards against that to ensure that we're not using DNA for purposes of perhaps identifying, as Mariano was indicating, health-related information or other information that could factor into an individual being able to receive immigration benefits. We also engaged in international collection and sharing. This was to safeguard our own borders and to learn about potential disqualifying criminal activity for entry or even benefits. So one thing I want to highlight, though, if you're interested, especially on the international front, because we're talking with an international group today, is that we issued privacy impact assessments. You know, one of my primary roles as the Chief Privacy Officer was to assess and mitigate potential privacy risks of unique technologies, programs, activities, anything that the department was doing that could impact privacy. And so these privacy impact assessments are available online. They may be in, quote, archived content at this point in time, but nonetheless, they still exist. So you can take a look at the ways in which the programs are used and the mitigation measures that were put in place to safeguard privacy. I know you asked about facial recognition, so I'll jump into that quickly. Facial recognition, again, is an easy example of the intersection of biometrics and the use of artificial intelligence. And so I'm glad that you brought this up because it really is one of the things that I mentioned before I'm most proud of from my tenure. And at the time, again, this is available in archived content on the web, but we developed and implemented at the department the U.S. federal government's first facial recognition and facial capture policy. And in part, that policy required that all uses of these technologies be thoroughly tested to ensure that there's no unintended bias or disparate impact, right, in accordance with national standards. And so I was a very big pusher of this being independent testing, right? We can't have an agency doing its own testing and then essentially say, trust us, it's all fine. So this was to ensure that independent testing occurred of agencies, both the use of their particular algorithms and the particular use cases. As I mentioned as well, U.S. citizens are afforded the right to opt out of face recognition for non-law enforcement uses. And what's really critical is that the policy provided that facial recognition or facial capture technologies and matching cannot be used as the sole basis of any criminal or civil enforcement related action. So again, to my international colleagues, I'm sorry, but for U.S. citizens, this is particularly important, but for everyone, it's important that there was a human in the loop, right? Corroboration of the output was required to be able to use the output for any enforcement purposes. And then finally, we really approached a privacy and security by design framework where we ensured that the department's oversight offices, including the Privacy Office, the Office for Civil Rights and Civil Liberties, and the Office of the Chief Information Officer reviewed all new and existing use cases. And so this, again, is a privacy by design framework. And I know we hear this as privacy professionals all the time, but how important it is to have the right people at the table when you are developing a new tool, technology, system, program, whether in the private sector or in a government setting. So we also took a look back. We assessed the current uses of the technology at the time to assess their compliance with the new policy, and we adjusted those uses accordingly. And we even issued a public report on our findings. So transparency is also key here, and something that was built into our framework of safeguarding privacy in the context of the use of facial recognition. So the last thing I'll flag is a particular kind of technological nuance, but this is something we see when it comes to facial recognition, no matter where it's used. And depending on where the threshold for a match is set within the algorithm, this can set the baseline for either enhanced security, which has greater implications, of course, for privacy, or lower security, which has heightened safeguards for privacy. So where the threshold is set really does affect the policies that should be in place to mitigate potential risks. So for instance, if a threshold is set to provide a match of, let's say, within 98% certainty, then many people may ultimately be determined to not be a match, even though they are who they say they are. And this can lead, for instance, in an airport circumstance, for an individual to being delayed or missing their flight or even detained. Again, even though they are in fact who they say they are. So you have to build in mechanisms to address this reality. For instance, to include simply reverting back to original authentication measures of visually reviewing and authenticating an identity document, not just, again, solely relying on the output. And of course, again, the lower threshold for a match, the more likely that individuals who are perhaps faking their identity can get through. So you can probably guess where the threshold was set at the department for this particular use case. And again, the safeguards we put in place were very much informed by the risks that the threshold setting could realize. So I'll turn it back over to you, Maria, but happy to take any questions on this.
Nice. I think we will move over to Mexico now, and with Alexis, I'll be quick. With the new national ID becoming mandatory, and you spoke before about the new data protection authority and how that's still a complicated issue in Mexico. What do you think are concrete safeguards that should be non-negotiable?
Well, first of all, we have to remember we do have even with the change of the authority, we do have comprehensive laws, and we do have laws that are very similar to GDPR, and we do have laws that have these core principles of strict necessity, proportionality, security safeguards. So what we have to look at is we especially as privacy lawyers or wherever we are that could impact and this concern we have of the processing of this data is that we should demand, one of the key things for me is we should demand transparency, right? We should demand transparency from the government in terms, and Mason I think was very clear on that, on the impact assessments. Has the government taking this impact assessment? Can they prove that this collection of biometric data is necessary, or are there any other ways to be less intrusive to achieve the goal? This is what we as privacy lawyers always ask ourselves. Do we really need this data? This data is sensitive. Can we achieve the same goal with the use of this data without processing this much data? That's the first thing, right? Second, we have to have rules. They have to have rules. When can we access that data? On what scenarios, right? And that has to be transparent, because we all as privacy lawyers know that when we go to a company and there's a database and there's a rich database and there's a lot of potential in that data, like could be in biometrics, it is very tempting to misuse the data. It's very tempting to repurpose the data. So one of the key concerns and one of the things that have to be in place are these measures for the government to avoid any misuse or any repurposing of the data, because that's normally where when the big risks materializes of that misuse of data. That's the first thing we want to avoid. We want to make sure that the data is only used for these security purposes. And of course, it's understandable in the state we have in Mexico and the security issues we have, and that we need technology to fight against crime and to fight against drug cartels and to fight against all the things, the problems we have. But we have to know that we have to balance it with the data protection right, that it's one of the rights that gets the most impact in regards with these technologies. And second, that and the second thing is that we cannot forget cybersecurity. When governments usually build these central platforms of intelligence, is what cybersecurity experts usually call they create a massive honeypot, right? This is so attractive to criminals. These databases are what criminals and hackers are always looking for. So we have our government has to understand this and be smart about it and take all these security measures that are necessary to protect the data. Because if this data is misused, the negative impact it could have on Mexican citizens, and we're one step closer to becoming a mass surveillance state if we don't take care, if we don't see the problem that could happen if this data is misused. So we're at a critical stage. I think our new data protection authority has a great opportunity to lead the way, to lead as an example on how biometric data should be used when it's in government possession, and that should translate to private entities also, because it's not only the government. We could have all these misuses in terms of HR in companies. So it's we're going to see what happens, but it's a key moment for Mexico and the use of biometrics.
Nice, perfect. And Leslie, Argentina, and Mariano, we can start to get a bit more specific here. We have seen a lot of important precedents on government access to biometric and other sensitive data. Buenos Aires itself has been recently at the center of the debate. Mariano, what lessons can be drawn from the decisions, and how do they shape the limits and expectations for law enforcement access to that biometric databases?
Sure, yeah, you mentioned a very important case. A few years ago, the city of Buenos Aires implemented a facial recognition system for identifying fugitives. This system relied on a live video feeds installed in the subways and public areas, and cross-checked those faces against a national registry of individuals with outstanding warrants. However, soon after the implementation of this new tool, an NGO called ODIA, in Spanish it means Argentine IT Law Observatory, filed a constitutional action, which is called in Argentina Amparo, challenging the system. It is a very brief proceeding. The claim was not about opposing the use of a specific technology per se, but about the absence of privacy safeguards that a biometric system, as this one, requires before going live. ODIA argued that the system enabled mass capture of biometric identifiers from anyone walking through public spaces, particularly in subways, without prior notice, transparency, or adequate legal basis, something that was mentioned by Alexis just before. ODIA highlighted as well the risk of false positive, because there was some cases of two or three cases of false positives, the potential for discriminatory bias, and the fact that biometric templates could hypothetically be retained or reused in ways incompatible with purpose limitation, which is an important principle according to the Argentine data protection law. And what was very crucial, or what was very important in the debate of this case, the government had not conducted a privacy impact assessment. Before entering on this debate, it is important to highlight that according to Argentine law, there is no mandatory data privacy impact assessment. It's just a recommendation of the Argentine authority, but it's not mandatory. The first instance judge dismissed the case, but on appeal, the Court of Appeal reached a very different conclusion. The Court of Appeal recognized that privacy, non-discrimination, and data protection rights were clearly at stake here, and that individuals could be harmed simply by being exposed to real-time biometric identification without safeguards. The Court of Appeal stressed, particularly in this case, that this was not a theoretical concern. Any person recorded by a camera could be subject to automatic processing capable of altering or affecting rights, individual rights, particularly considering that in Argentina, data protection is a fundamental right. And especially considering as well because the system revealed that there was kind of false positives. Because of all these risks, the court decided to suspend the operation of this system until robust measures were implemented. And which means this? Well, first of all, the City of Buenos Aires must implement a data protection impact assessment. Secondly, an independent oversight mechanism is required. Third, a safeguards against discriminatory outcomes should also be implemented in the case. And also the authorities must deploy controls over data retention, access, and auditability. To wrap up, the case is very important for us because it reinforced, in a sense, three principles that are very relevant in Argentina. The first one is that public sector of the use of biometrics by public sector must meet the privacy standards. All the principles and the provisions that were mentioned by Alexis and Mason: transparency, data privacy impact assessment, minimization, proportionality. All these must be considered when implementing or deploying this kind of tools, which, as mentioned by Alexis, they are very important and they could reveal some kind of problems to human rights and so on and so forth. The second one, that an impact assessment is necessary in those cases. And the third one is that the courts are willing to intervene in those cases in which human or fundamental rights are in danger. So basically, that was one of the most important cases here in Argentina so far.